So this lecture is going to be the lecture of malicious prosecution. Okay, and this topic has already been asked several times by UPSC in paper 2 of UPSC law optional. Okay, and there was in 2024 a question that related two topics. Okay, so there were certainly two topics that were together asked in that question. Okay, that was basically the question number 3. Okay, it was of 15 marks. Okay, question number 3C part. Okay, of the second paper of UPSC Law Optional 2024. The question was explain false imprisonment as per law of torts and distinguish it from malicious prosecution. तो उसमें एक false imprisonment को पूछा गया था, define the false imprisonment and distinguish it from malicious prosecution. तो malicious prosecution से उसको जो है differentiate करने के लिए कहा गया था. ठीक है, चलिए स्टार्ट करते हैं इस लेक्चर को. सो बिफोर डूइंग एनीथिंग, बिकॉज दिस लेक्चर इज द लेक्चर ऑफ malicious prosecution, so before starting anything we have to first study what malicious prosecution is. Okay, so let us start with malicious prosecution. See, malicious prosecution, so just imagine one thing, just imagine that if the law, that law is in the society, basically the law is made for the people to avail justice. The law is basically the rational instrument without any passion that is used to basically disperse justice in the society. All right. But just imagine about a situation when the law itself is used against you to basically harass you. Is the situation when this law itself is used against you. Are you getting the point? So those such situations also come, है ना? In those situations the law sometimes turns against you in the court of law. All right, now just understand what this malicious prosecution is. So this is about what if the law itself becomes a weapon. This can be a situation, right? So now just understand this thing. So for example, for understanding this particular topic, let us first understand a particular case. All right, for example, there is a plaintiff. Okay, there is a person A who is a plaintiff. All right, so plaintiff is a person who has basically came to the court with a claim to submit its claim to basically file a case. Okay, to start a prosecution. Okay, so एक A is a person जिन्होंने क्या किया, prosecution को start किया. He started a prosecution against a defendant. All right, against whom? Against a defendant. Okay, so this plaintiff has filed a criminal case against the defendant. All right, now this is the defendant. In this case, now for example, what happens? The defendant is found to be innocent. Okay, तो अब मान के चलो कि इस केस में जो इंसान इनके अगेंस्ट, ही इज पर्सन बी. नाउ इनके अगेंस्ट जो केस फाइल हुआ था कोर्ट में, तो ये अल्टीमेटली क्या हुए, ये इनोसेंट प्रूव. कि ये क्योंकि इनोसेंट प्रूव हुए, तो बाद में ये बात समझ में आई, बाद में ये बात पता चली कि इनके अगेंस्ट जो केस किया गया था, दैट केस वाज नॉट एट ऑल विथ प्रॉपर इंटेंशन. दैट केस वाज फाइल्ड बाय दिस पर्सन अगेंस्ट द डिफेंडेंट विथ मैलिशियस इंटेंशन, विथ मैलिस. किसके साथ? मैलिस के साथ. ठीक है, सो इन दैट केस व्हाट डू यू थिंक, should B be compensated for the loss that he has faced, for the humiliation this person has faced? Should he be compensated for this thing? क्योंकि इनके अगेंस्ट प्लेंटिफ ने केस किया, जिस केस में जो है इनके अगेंस्ट इनको हरासमेंट हुई, इनको जो है इनका टाइम गया, इनकी सोसाइटी में बदनामी हुई, तो क्या इसके लिए इनको कंपेंसेशन मिलना चाहिए? This is a very big question in front of us. All right, so now we are able to understand this thing, that malicious prosecution means the wrongful use of the legal process. It is the wrongful use of the legal machinery. All right. So here in this malicious prosecution, four things are involved. The first thing is it is basically a criminal proceeding. Here we just saw first A started a criminal proceeding against B. Okay, so first thing is clear. Now this criminal proceeding that was started by A against B by plaintiff against the defendant was without any reasonable cause. There was no reasonable cause at all for initiating this proceeding. All right. Now, one more important thing is this was having malice in it. ठीक है, it was having personal interest in this, it was having wrong intention in this on the part of A to initiate a legal proceeding against B. Getting the point? इसमें पता चला and now this ends in the favor of the plaintiff. The person who started this proceeding, ये proceeding इनके फेवर में हो गई. ठीक है, तो ये चीजें इसमें मस्ट है और आगे जाकर के हमें ये पता चलता है कि ये जो है विद मैलिस था और इसमें कोई रीजनेबल कॉज नहीं था. ठीक है, नाउ व्हाट हैपेंस, नाउ टू सक्सीड प्लेंटिफ मस्ट प्रूव. ओके, नाउ फॉर बेसिकली प्रूविंग एनी प्रोसीडिंग टू बी मैलिशियस प्रोसिक्यूशन, जो प्लेंटिफ है उन्हें क्या क्या चीजें प्रूव करनी होगी. उन्हें पहली बात तो ये प्रूव करना होगा कि द प्रोसिक्यूशन बाय द डिफेंडेंट. तो मैलिशियस प्रोसिक्यूशन में क्या होता है, जस्ट अंडरस्टैंड दिस थिंग. पहले क्या था, ए ने जो है ए यहां पर था प्लेंटिफ और बी यहां पर था डिफेंडेंट. ए ने बी के अगेंस्ट केस किया बट बाद में पता चला दिस वाज विदाउट बेसिकली एनी रीजनेबल कॉज एंड विथ मैलिस. तो जो अभी यहां पर डिफेंडेंट थे अब ये क्या बन जाएंगे, अब ये बन जाएंगे plaintiff. All right, now he will become the plaintiff. All right, and now this plaintiff, because he was earlier the defendant, he will start prosecution against A. All right, now he will become plaintiff. So in malicious prosecution, the prosecution must be started by the defendant who was earlier defending himself, but now he started prosecution against A. All right. So the first thing is that the prosecution here must be started by the defendant. All right. There must be absence of any reasonableness and any probable cause. Okay. So in the first place, when the case was filed, when the criminal proceeding was started by A against B, so it must be proved that there was no reasonable or no kind of probable cause in this particular type of proceeding. All right. There was no cause or no reasonableness in this, and there involved malice. Okay, personal interest, wrong intention. All right, so there was malice involved in this, and the termination was in the favor of this person. All right, and there happened damages to this person. All right, तो इनके साथ क्या हुआ, इनको क्या फेस करना पड़ा, इनको damages फेस करने पड़े. आ रही है बात समझ में? Now they faced damages. All right. So now coming on to the main point. So before starting this case, let us write what we have studied. All right. So I will make you write. I will dictate you the things and then please note the things down. All right. So put up first question. What is the meaning of malicious prosecution? So just write what is the meaning of malicious prosecution. This must be your heading. What is the meaning of malicious prosecution? Right? A malicious prosecution is a judicial proceeding. A malicious prosecution is a judicial proceeding initiated by one person. Initiated by one person against the another person. Okay, so this is a proceeding that is started by one person against the another person without reasonable and probable cause, without any reasonable and probable cause. ठीक है, जो प्रोसीडिंग एक ने दूसरे के अगेंस्ट स्टार्ट की उसमें कोई प्रोबेबल या रीजनेबल कॉज नहीं था, एंड विद मैलिशियस इंटेंशन, and with malicious intention, and in the bracket you can write improper motive. Malicious prosecution, and in the bracket write improper motive. And also write one very simple definition, just change the point and then write, it is the wrongful use of, it is the wrongful use of legal process, it is the wrongful use of the legal process to harass someone, to harass someone and not to seek justice. इसका काम क्या था? इसका काम जो है जस्टिस लेना नहीं था. इस प्रोसिक्यूशन का काम ये नहीं था कि टू अवेल जस्टिस. इस प्रोसिक्यूशन का काम क्या था? इसका काम था गलत तरीके से प्रोसीडिंग्स को आगे लेके जाना, जिससे कि सामने वाले व्यक्ति को हरास किया जा सके, so as to harass the person in front of it. All right, so now this the essential element क्या है इस केस के, है ना, इस malicious prosecution के. देखो सामने एक केस है, इस केस को जो है हम समझेंगे, वी विल अंडरस्टैंड दिस पर्टिकुलर केस, बट देयर आर सम एसेंशियल एलिमेंट्स दैट आर पुट फॉरवर्ड बाय दिस केस. So just note down this case, West Bengal State Electricity Board versus Dilip Kumar Rai case 2006 to 7. Just note down this case. Right? In this case, the following essential elements were laid down by the Supreme Court. Were laid down by the Supreme Court. Supreme Court ने कुछ essential elements बताए थे इस केस में. Those essential elements are required to prove a case to be the case of malicious prosecution. ठीक है? So write the first one: absence of reasonableness and probable cause. Absence of reasonableness and probable cause. Absence of reasonableness and probable cause. It means that no legal, it means that no legal basis exists for initiating the proceedings. ठीक है? इसका मतलब क्या है? इसका मतलब ये है कि प्रोसीडिंग्स को शुरू करने के लिए कोई लीगल बेसिस था ही नहीं. ए ने जो बी के अगेंस्ट लीगल प्रोसीडिंग्स को स्टार्ट किया, उन लीगल प्रोसीडिंग्स को स्टार्ट करने के पीछे का कोई लीगल बेसिस था ही नहीं. Getting the point? So this is the very important point, that there was no legal basis for starting that proceedings. ठीक है? Also write a reasonable person. कि भाई कोई भी एक reasonable person जो होता, a person who is reasonable by mind, कोई भी reasonable इंसान ऐसी proceeding को start नहीं करता. So right, a reasonable person would not have filed the case. ऐसे केस को हम क्या बोलेंगे? ऐसे केस को हम बोलेंगे कि भाई मलेशियस प्रोसिक्यूशन का केस है, ठीक है, कि कोई रीजनेबल इंसान ऐसे प्रोसीडिंग को इनिशिएट करता ही नहीं, ठीक है। So this was the first essential element let down in the West Bengal Electricity Board versus दिलीप कुमार दे केस, ठीक है। सो अब सेकंड लिखो, सेकंड proceedings terminated in favor of plaintiff। तो ऐसे में यहां कौन है प्लेंटिफ? जो अभी प्लेंटिफ है इस मलेशियस प्रोसिक्यूशन के केस को करने के लिए। फॉर एग्जाम्पल ए ने, जैसे यहां पर हमें पता है कि ए ने बी के ऊपर पहले केस किया था, ए वॉज द प्लेंटिफ एंड बी वॉज द डिफेंडेंट। नाउ व्हाट हैपेंस, नाउ दिस पर्सन फील्स दैट ही हैज फाइल्ड द केस अगेंस्ट हिम विद मैलिशियस इंटेंशन, improper motive. Now he becomes the plaintiff and he can only start the malicious prosecution proceedings against A when the judgment that was delivered here was in his favor। इनके फेवर में जजमेंट आया और इनको लगा कि मेरे फेवर में तो आना ही था जजमेंट, जब मेरी गलती नहीं थी और इन्होंने बिना वजह के मेरे अगेंस्ट केस किया था। नाउ ही विल बिकम द प्लेंटिफ एंड विल sue whom? And will sue A। All right, so right, the case must end, the case must end in favor of the person prosecuted, in favor of the person prosecuted, right, in favor of the person prosecuted। Okay, example, acquittal in criminal cases। example, right, acquittal in criminal cases। ठीक है, तो ये सब जो है मेजर रिक्वायरमेंट्स हैं टू इनिशिएट द प्रोसीडिंग्स ऑफ malicious prosecution। देखो, देयर इज ऑलवेज अ क्वेश्चन नाउ, मेलिस क्या है? देखो, मेलिस इज इम्प्रॉपर मोटिव। ओके, मेलिस, अच्छा लिखो, राइट, व्हाट इज द मीनिंग ऑफ मेलिस? MALICE लिखा होगा, मेलिस, राइट, व्हाट इज द मीनिंग ऑफ मेलिस? देखो, ऐसा नहीं कि कोई हेट्रेड, इट डज नॉट ओनली मीन्स हेट्रेड, गुस्से में नहीं, हेट्रेड में नहीं, डजंट मीन्स हेट्रेड। मेलिस का मतलब होता है इम्प्रॉपर यूज, राइट। Malice does not always means ill will or hatred. Just a second. Means ill will or hatred, but it includes improper purposes and indirect motive. Improper purposes and indirect motive, and not acting in furtherance of justice, and not acting in furtherance of justice। बात आ रही है समझ में? है ना? हाँ, right, examples, right, filing cases to harass, defame, ठीक है, filing the cases to harass, defame or pressure someone. ठीक है. So now one case is there. All right, one very important case is there. So let us understand this case. This is West Bengal State Electricity Board versus Dilip Kumar Rai. Okay. Now just imagine. Now we are just talking that some person is filing a case against you with malicious motive. Okay, with malice. But now in this case, what happened? Now, in this case, the West Bengal State Electricity Board was an organ of state, and here the see this case is very unique because here it's state body versus some person. So here what was done was the state body basically filed a case. Okay, now in this case what happened, the person who was Dilip Kumar Rai, he was the he was a person who was an employee under the state in this board only. And what the board did, they basically they basically removed that person from the job and instated a proceeding, okay, a criminal proceeding against this person. All right, now this case was taken. Now in this case is the case of misuse of the legal machinery and the false prosecution by the authorities, in which he sought compensation. Now in this case what happened, what if a government authority wrongly accuses you? So in this case the electricity board wrongly accused the person, all right, of committing some theft. Okay, now this board accused the person, but initially, what happened? Initially, in the West Bengal High Court, what happened in the West Bengal High Court? The judgment that was delivered, what it was in favor of the electricity board only. Okay, they basically found that he has basically committed that offense, due to which the electricity board has removed him from his duties. But when this case was taken to Supreme Court, the the Supreme Court gave a very different verdict in this case. All right. So now he was in the Supreme Court proved to be innocent, and it was found that there in the Supreme Court it was found that this case was having the element of malice. Okay, this was basically done with malicious intention. Okay, malicious motive. So in this case only, these two essential elements that I just dictated you were established, came to be known, and a judicial precedent got established that while checking whether a case is a case of malicious prosecution or not, you will have to wonder from two angles. First, you will have to see whether there was absence of reasonable and probable cause or not. If the reasonable or the probable cause was there, then this particular case is not the case of malicious prosecution. But if reasonable and probable cause was not there, then this case is the case of malicious prosecution. All right. And also the proceedings were terminated in favor of the plaintiff. All right. Who now became the plaintiff. Earlier, who was the defendant. All right. So let us just write this case. Okay. Let us just write the illustration of this case first. So just write, give the heading, West Bengal State Electricity Board versus Dilip Kumar Rai case. Right? The employee, in bracket write Dilip Kumar Rai, was suspended from service by the board, was suspended from the service by the board. Right? Disciplinary proceedings were initiated by the employer. Disciplinary proceedings were initiated by the employer. And FIR was lodged against the employee. right? The criminal proceedings were then dropped and no conviction or continuation of prosecution happened. Okay. Now, right, the decision of the lower court, the decision of the lower court was that the employer was held liable. The employer was held liable and it awarded damages to the employee. It awarded damages to the employee for harassment, comma, loss of reputation, loss of reputation, and misuse of the legal machinery, due to which mental sufferings were caused to the employee. Mental sufferings were caused to the employee. Okay. So now what happened, right? The Supreme Court reversed the judgment of the lower courts. Okay. Now what Supreme Court found, that there was, first thing, absence of proper pleadings. Okay. So see, one very important thing here is that in case, now just reimagine this case, now in case A instituted a proceeding against you. Okay, now in this case, A is the plaintiff, B is the defendant. All right. Now here B becomes the plaintiff and now again filed a case against A on the ground of malicious prosecution. It is very much required that this person, so this case must have been a proper criminal case. If this was just a FIR, if this was just a police complaint and not a proper legal prosecution, in that case you cannot file a malicious prosecution case. Getting the point? So the first and the foremost thing is, right, number one, absence of proper pleadings. Absence of proper pleadings. Right. It was stated that no clear assertion of, it was stated that no clear assertion of malicious prosecution can be made because the essential ingredients were not specifically pleaded. In the second point, right, vague and contradictory findings. Vague and contradictory findings. Right. The lower court failed to establish, the lower court failed to establish that who initiated the prosecution, comma, whether it was malicious or not, and whether there was absence of reasonable cause or not. Okay. And also write third point. In third point, we will write that there was actually no proof of malice, whether there was malice or not. Okay. So write failure to prove essential element. Right. There was no proof of malice, comma, lack of reasonable and proper cause, and proper prosecution by defendant, and proper prosecution by defendant. All right. So here the legal principle, right? Legal principle that got established was that mere, just understand first. So that means for calling a particular proceeding as malicious, you'll have to prove that that proceeding was in the court, a proper criminal proceeding. A person just lodged a FIR and you are calling it a malicious proceeding, that will not happen. A person just suspended you. Okay, so suspension does not automatically amounts to malicious proceeding, the prosecution. All right. So now, right, mere filing of FIR, mere filing of FIR, comma, suspension from designation or dropping of proceedings does not automatically amounts to malicious prosecution. It does not automatically means that malicious prosecution has happened. Right. So plaintiff must strictly prove all the essential elements. All right. Those essential elements must be proven properly. All right. So here we go. Now see, we will be understanding the essential elements of malicious prosecution. All right. So there are certainly 5 essential elements of malicious prosecution. These essential elements we will be discussing in detail. All right. So the first is prosecution by the defendant. That means the prosecution who was basically earlier in this case A started a malicious prosecution against on the malicious ground a proceeding against B. In this case A is the plaintiff and B is the defendant. Now he can start malicious prosecution against A on the ground that earlier A started the criminal proceeding against me on malice ground. All right. Second is absence of reasonable and probable cause. You can say that there was absence of any kind of reasonable and probable cause in this case. All right. Third thing is there must be the ingredient of malice involved in it. That is improper motive. Okay. Fourth is termination in plaintiff's favor. All right. Now this person is the plaintiff and the result of this proceeding was in his favor. All right. It was in this person's favor. Okay. Then only he can initiate this proceeding. Okay. Damages to the plaintiff. Now, in this case, it can also be stated that this person, because plaintiff has started this criminal prosecution against this person on wrong grounds, on malice ground, and due to which this person has suffered certain damages. Okay, certain damages has come to this person. Okay, so this is particularly the major elements. All right, so we will be discussing the first thing, that is prosecution by the defendant. All right, so in this case the prosecution is there, so the defendant, so let us just understand. So for example, A started a criminal proceeding against B. In this case, A was a plaintiff, B was the defendant, and this is with malice. Okay, this is with malice. Now this malicious prosecution proceeding against A by B. So B here was the defendant. So he can only initiate the the malicious prosecution against A. All right. So here, first of all, let us understand what is the prosecution. What is the meaning of prosecution? All right. So in basically the malicious prosecution case, so prosecution is criminal proceeding. That means A, we just understood this thing, that A initiated a malice proceeding against B. What does this proceeding means? What does this mean? इसका मतलब है, इस proceeding का मतलब है, it must be a criminal proceeding in the court. ए ने बी के अगेंस्ट एफआईआर कराई, उसमें आप फिर जो है बी ए के अगेंस्ट मैलिशियस प्रोसिक्यूशन का केस नहीं कर सकता है. इसमें ये रिक्वायर्ड है कि जो ए ने किया बी के अगेंस्ट वो एक क्रिमिनल केस था. अगर ये क्रिमिनल केस नहीं था तो उसके बदले में आप मैलिशियस प्रोसिक्यूशन की प्रोसीडिंग स्टार्ट नहीं कर पाओगे. तो इट वाज अ क्रिमिनल प्रोसीडिंग, राइट, नॉट अ सिविल प्रोसीडिंग. ठीक है, ए ने आपके अगेंस्ट सिविल प्रोसीडिंग की, आप बोल रहे हो कि आप उनके अगेंस्ट मैलिशियस प्रोसिक्यूशन का केस करोगे, नहीं कर पाओगे. All right, in a court of law or judicial authority. All right, so to prosecute is to set the law in motion before a judicial authority. तो prosecute का मतलब यही होता है कि आपने लॉ का इस्तेमाल किया to set up proceeding against the another person. All right, so this is what now B is essential clarification is required. So what are the only criminal proceedings? So any civil case will not be considered as criminal proceeding. So the prosecution means criminal case. All right. It must be criminal charge. It must be under judicial adjudication. All right. So this is very much required. Now talking about the next thing, proceeding before police or is not prosecution. A went to police to file FIR. Now this is not prosecution. So against this act, you cannot initiate the malicious prosecution against A. All right. So filing complaint, police inquiry, these are not the cases of prosecution. Okay. So here in Nagendra Nath versus Jacob Chandra case, it was also held that mere filing complaint does not amount to prosecution. All right. So when does prosecution begins? When does it begins? When the magistrate in the court of law takes the cognizance of a matter. At that time, we can say that A has initiated a prosecution or proceeding against B. अब जिसके लिए B जो है वो जा सकता है ए के अगेंस्ट इन चार्ज ऑफ मैलिशियस प्रोसिक्यूशन. ऑलराइट, तो वही राजेंद्र नाथ वर्सेस जैकब चंद्र केस है. ठीक है, a proceedings before police is not considered. Now who is a prosecutor? A person who sets the law in motion. A person who starts the proceeding is called as prosecutor. So इसको लिखो, write this thing, right? Write the elements. Okay, put the main heading, essential elements of malicious prosecution. Write the first one, prosecution by the defendant. Prosecution by the defendant. Okay, prosecution by the defendant. So now put the first heading, that is right. There, put the first main heading, there must be a prosecution. A plaintiff, B defendant, A B के अगेंस्ट एक prosecution कर रहा है, that means एक criminal case कर रहा है, ठीक है. So right, the first and the foundational requirement to start a proceeding for malicious prosecution is that there must be a prosecution. There must be a prosecution. There must be a prosecution. All right, who is a prosecutor? Yeah, as a prosecutor, though, you know who sets the law in motion. But now, right, what is a prosecution? Prosecution hota kya hai? What is a prosecution? Right, prosecution refers to a criminal proceeding and not a civil case. Which was initiated in a court of law or judicial authority. Okay, so now write another point. Only criminal proceedings count. Right, only criminal proceedings counts. अगर ए ने बी के अगेंस्ट एक सिविल जो है केस किया है, तब आप उसके अगेंस्ट मैलिशियस प्रोसिक्यूशन का केस नहीं कर सकते. सिविल में नहीं होगा, क्रिमिनल जरूरी है, ठीक है. सिविल प्रोसीडिंग्स आर जनरली नॉट prosecution, and it must involve criminal charge and judicial adjudication. Yeah, so the next here is proceedings before the police. Put this heading, proceedings before police is does not means prosecution. Okay, so the proceedings that goes on before the police does not amounts to prosecution. Okay, so just write here, right? Police investigation is only the preliminary stage and it does not amounts to prosecution. Okay, it does not amounts to prosecution. पुलिस जो करती है वो तो बस एक प्रिलिमिनरी स्टेज है. Okay, and now you can write in Nagendranath, versus Basant Das Bairagya. Basant Das Vairagya case, it was held that no prosecution existed because only police action is not sufficient to call as prosecution. तो ऐसा कब स्टार्ट कब होता है फिर प्रोसिक्यूशन, राइट? व्हेन डज प्रोसिक्यूशन एक्चुअली स्टार्ट? कब होता है फिर स्टार्ट? ना, दिस इज अ क्वेश्चन, देन व्हेन डज इट एक्चुअली स्टार्ट? ओके, सो जस्ट राइट prosecution begins when judicial authority is involved. When judicial authority is involved. The time when judicial authority will come to the play, at that time we can say that a plaintiff has initiated a prosecution against the defendant. And also right, and does not begins when only complaint is filed and only police investigation happens. All right. And also right, Hagendra Nath versus Jacob Chandra. Case, it was held that mere lodging of complaint, that mere lodging of complaint and no arrest and no trial does not amount to prosecution, and hence no action can be taken for malicious prosecution. All right. Any problem? Clear? So this was basically the first thing. But here a question comes. Now, for example, there is a quasi-judicial authority involved. I'm saying that, for example, what will happen? I'm saying that when A, for example, loads a FIR against B, it will not a prosecution. But when he finally filed a case and judiciary comes in against B, here B is the defendant, A is the plaintiff. This will be prosecution, and if this is basically malice, then in this case B can again start the proceeding against A under malicious prosecution. But I am saying that if A initiated a proceeding not in the judicial, not in the court of law, but in quasi-judicial body. Okay, so like election commission, even a magistrate, the district magistrate, these are quasi-judicial bodies. So for with regards to this, in India there are two views. Okay, the first is the liberal view and another one is the strict approach. Okay, by the liberal view, it is basically stated that the proceedings in front of the quasi judicial bodies amounts to prosecution, but the stricter approach says that the proceedings in the quasi judicial bodies basically does not amounts to prosecution, against which the proceedings of malicious prosecution cannot take place. Just divide the page, okay, into two, right? Liberal view, right? Stricter view. In the liberal right, Kapoor Chand versus Jagdish Chand. You're right. There was in this case actually there was a false complaint in front of the medical board. Okay, so it was a false complaint and the board cleared the respondent, and basically it was held that such proceeding that was there in front of the medical board, which is not a complete judicial authority but a quasi judicial body, so in this case the compensation is allowed, and basically in this case it will be called as the prosecution. All right, so right, a false complaint, in this case a false complaint was filed before the medical board, was filed before the medical board, and the board cleared the respondent, and it was held that, and it was held that such proceedings amounts to prosecution, and compensation is allowed. Okay, compensation is allowed. All right, and the reason that was given was that such authorities performs judicial and quasi judicial functions. Okay, in the stricter view, right, DN Bandyopadhyay versus Union of India case. ठीक है, इसमें लिखो, इसमें राइट, in this case इसमें departmental inquiry was there against the employee, and later this departmental inquiry was set aside. So it was the question that whether this departmental inquiry will be called as a prosecution against which the employee can file a malicious prosecution case. So it was held that it was not a prosecution. So right, in this case there was a departmental inquiry against an employee, departmental inquiry against an employee, which was later set aside, which was later set aside. All right. Later on, this departmental inquiry was set aside, and right, it was held that this inquiry was not a prosecution because such a body is a quasi judicial body. Or administrative body. Okay. Now coming on to the next element. All right. So let us see the ingredient next, main ingredient, that is the absence of a reasonable and probable cause. All right. Now in this case, like for example, A started a prosecution against B. Now we understood what does this prosecution means. It started a prosecution against B. Here it was the plaintiff, it was the defendant. Now this particular prosecution was not having any reasonable and probable cause. It was without any cause. Now if it is without any reasonable or probable cause, we can file a case of malicious prosecution against A. But here we need to see that what is basically the meaning of the absence of reasonable and probable cause. It means that when the plaintiff is initiating a prosecution against the defendant, there is no honest belief or there is no reasonable basis for calling this prosecution as valid. Okay, this means that there is absence of either no honest belief and no reasonable basis for doing this. All right, the key component is that there is no honest belief, and no reasonable ground for basically starting this particular prosecution. And the clarification is that mere suspicion is not enough, proof of guilt is also not enough, but there must be a reasonable case to go to the court. Okay. Now, so for example, in a false arson allegation, a 55,000 compensation was granted. Even in Shiv Shankar Patel case, 8 years, there was 8 years of baseless trial that happened. This case will also considered to be as the case of non-reasonable and lacking a probable cause. All right. So there must be sufficient ground and proper inquiry must be there. Okay. So then only you get the right to prosecute. Okay. So now just write this, write the main heading, absence of reasonable and probable cause. Absence of reasonable and probable cause. Here write, the plaintiff must prove, the plaintiff must prove that the defendant, that the defendant initiated the prosecution without, initiated the prosecution without reasonable and probable cause. Okay, without reasonable and probable cause. All right. It means there lies, yeah, exists. Hang on. Okay. So now we were just writing the second essential element. Okay, so just write the definition in that. So it is an honest belief. Okay, it is an honest belief in the guilt of the accused. Honest belief in the guilt of the accused based on, based on reasonable grounds, reasonable grounds which would lead a prudent person, which would lead a prudent person to believe that the accused is probably guilty. To believe that the accused is probably guilty. ठीक है, यहां एक ऐसा बिलीव जो कि रीजनेबल ग्राउंड पर बेस्ड है, जिस बिलीव को एक एक जो भी प्रूडेंट इंसान जो है अगर सुनेगा तो उसको ये लगेगा कि सामने वाले इंसान ने पक्का कुछ गलत किया होगा। ठीक है, तो अब देखो इसके कुछ की कंपोनेंट्स हैं इस कॉन्सेप्ट के। सो उसमें लिखो, mere suspicion is not enough. Mere suspicion is not enough and proof of guilt is not required. And proof of guilt is not required. And also probability of conviction is not required. Probability of conviction is not required. All right. The only requirement is that a reasonable case to approach court. ठीक है, to approach court. So now coming on to the next main intention, next main essential ingredient of this, that is malice. Now what is malice? Now we are just saying that A has started a criminal prosecution against B on malice ground. All right, that means it means that it is you, the person is using the legal process not to seek justice but to achieve some wrongful purpose. The objective is to achieve any sort of wrongful purpose. All right, so it has improper motive, it has wrong intention, maybe indirect purpose, or basically the use of law for any purpose other than the legal purpose. All right, malice is basically subjective. It talks about the motive of the person and is independent. All right, but on the other side, to other things like absence of reasonable cause is objective. Okay, you can prove that whether there was absence of reasonable cause or not, but you cannot prove on paper. Factually you cannot prove malice. Okay, malice cannot be proven factually. So now improper motive, wrongful intention, indirect purpose, use of law for any other means other than the legal purpose. What not amounts to malice? See, enmity with someone, anger, irritation, okay, acquittal of the accused. These all things doesn't amount to malice. Okay, these all things are not malice. So what is the core idea of malice? It is if the justice is that if the prosecution is used not for justice, to harass someone, to defame someone, to take revenge for someone, or to settle the personal scores. All right. If the prosecution is used for these things, then it will be said to be malice. All right. So just start writing malice, put a heading malice, and write a question. What is the meaning of malice? What is the meaning of malice? Right? The plaintiff must prove that the plaintiff must prove that the defendant acted with malice. that is improper or indirect motive, which means use of legal process, which means use of legal process not to seek justice, not to seek justice, but to achieve some wrongful purpose. Not to seek justice, but to achieve some wrongful purpose. All right. So this is basically the definition of what malice stands for, what malice means. And for you to start a malicious prosecution against the another party, it is required that the another party has already started a prosecution against you, where there was no reasonable or probable cause in that prosecution, and there was malice in that prosecution. ऑलराइट, उस प्रोसिक्यूशन में मैलिस, ठीक है, in that case only you can say that you can start malicious prosecution. All right, so from this malice topic we will be continuing in the next class. Okay, so just bear for just one day for the next part to come. All right, so we will be discussing in the next class. Okay.